because of the soupçon of corruption that goes around, the quid pro quo that someone who contributes to a campaign might ask for. But an independent expenditure, where you're not coordinating with the campaign, that's just speech. That's just First Amendment. You can't put limits on that for either corporations or for individuals. So that happened. Or you can't put prohibitions on it, some limitations. What the independent electioneering communications law became after it became Feingold, which was 2002, anyway, somewhere around there, is that corporations and unions, if they broadcast ads within 30 to 60 days of a primary or general election, it was a crime, a felony. So, and the reason, anybody can guess what the reason for that is? Well, first of all, it was in the not thinking that there was cable or internet or anything else, and looking at the limitation of the limited number of minutes that were available for broadcasting ads before an election, number one. And number two, if a corporation was able to buy them all up just before the election, then other people, number one, wouldn't be able to respond because there would be nothing left on the air, and two, all that money would get poured into the campaign at the last minute, and others would not have enough money to respond to that. So that was a dual purpose of that. And then finally, on issues expenditures, they're just disclosure requirements. All of these things have disclosure requirements. One can argue how effective they are, but they're there. The stuff gets filed with the FEC and in the state elections as well. And if anyone has questions throughout this and wants to shout out, please feel free. The resulting FEC, Federal Election Commission regulations, are very, very intricate, complex, and onerous. The distinctions may sound simple, but it is quicksand. And this is a quote from Citizens United, and I have not seen anybody say this is not true. That the campaign finance regulations impose rules on 71 entities, different kinds of entities, 33 different kinds of political speech, 568 pages of regulations, 1,200 pages of explanations and justifications, 1,700 advisory opinions since 1975, all of which, if you are a campaign finance lawyer, which I used to be, and advising a corporation about that, you have to figure out how to navigate through. My favorite part about this is that there's a two-part 11-factor balancing test with respect to certain kinds of speech. And I would ask you what kind of magician knows how to balance 11 parts. I mean, you're balancing 2, maybe 3, but 11, that's very, very hard. So that's the landscape before Citizens United. What happened in Citizens United? Citizens United was a nonprofit corporation. Who financed Citizens United? Not entirely clear. I mean, that's where sort of the limits of disclosures. You have to say, you have to disclose sort of some things about it, but not everything. And there were some major corporations and major Republicans who were on the board of Citizens United. So we don't really know that much about who they are. They wanted to show a pay-per-view broadcast of Hillary the movie. Has anybody here seen Hillary the movie? I haven't. I don't know. It's supposed to be fairly scurrilous. It was a documentary critical of presidential candidate Hillary Clinton, who at that time was the threat to the Republican Party. And they wanted to show it and trailers for it within 30 days of certain presidential primaries. So as you well know, during the course of 2000... and if I did, they made me. No, basically there was a presidential primary. I mean, so that there was a very long period of time in which they would not be able to broadcast these ads. Perhaps they were unsure. They didn't know whether broadcasting this ad or the trailers would violate the Cain-Feingold and subjected to criminal liability. So they asked a district court for a declaratory ruling, an injunctive relief, to tell them whether they could go ahead and do this. Now, obviously this was a test case. Obviously they knew they weren't going to be able to find out within 30 days whether they could do this or not. It was going to go all the way up. But, you know, and some cynical people say that they were constructed precisely for that purpose, to challenge the law. But in any event, the district court ruled for the FEC and said that, in fact, this was illegal, and there's a direct appeal to the Supreme Court. So it's a fairly simple case, a fairly narrow issue. Could this nonprofit broadcast this ad? Or subject, and with that subject, it's to criminal liability. What the Supreme Court said and did in a nutshell, and procedurally, this was not before the Supreme Court. They decided that Citizens United had gone ahead and put a very narrow question at issue before the Supreme Court. And the Supreme Court heard argument, and then over the summer said, we want further argument on this issue, which is corporate speech. And it really shocked the heck out of everybody. But so they went ahead and did it. I mean, these were the people who had been railing against activist courts. In any event, what the Supreme Court said and did was that you may not distinguish between corporate and non-corporate political speakers under the First Amendment. That the complexity of the existing system is akin to a prior restraint. So people know what a prior restraint is? It's like the big bogeyman of First Amendment law, which is the government may not pass a law that's a prior restraint on speech, that stops the speech before it even begins. It can, after the speech occurs, try and stop the speech or do some penalize the speech if it has good and sound reasons. But it may not do a prior restraint. In some ways, because Citizens United felt it had to ask permission to speak because it didn't know whether it would be criminally liable or not, that's a prior restraint. The not being willing to distinguish between corporate and non-corporate political speakers under the First Amendment came from a fairly simple concept. The First Amendment says Congress should make no laws restricting speech, not speakers. The majority opinion said that over and over again. Some of us who spend a lot of time with First Amendment law say that's a crock. There are all sorts of ways in which the First Amendment, in practice, gets distinguished between different kinds of speakers. Children in schools don't have the same First Amendment rights that adults do. Military employees don't have the same rights as civilian employees. Government workers don't have the same. I mean, there are lots and lots of distinctions in First Amendment law, but the majority chose to ignore those. But the actual ruling applied only to the McCain-Feingold prohibition on electioneering campaign communications. It didn't reach, it expressly did not reach whether other restrictions on corporate election-related speech, like direct campaign contributions, are constitutional. Now, under the reasoning, it would be very hard not to find them unconstitutional. The holding is narrow, the reasoning